Can you even believe it? The Supreme Court of the United States voting down affirmative action after 40 years of increasing equitable college access. We are just ripping away an important set of procedural supports for students from underserved populations. I'm so sick of this rhetoric, the way that we spin narrative in this country. Listen, I've been an educator for well over 20 years. I'm in the trenches of college access. I oversee initiatives. I oversee research. I have committed my career to understanding these things. So when I tell you, for people who understand the deep underpinnings of the college admissions system, as we're looking at this, there is a huge lament that is happening. And I am just going to share some of my thoughts, and I just want you to know that one of the real things that's sticking in my craw right now is they're not talking about legacy admissions. No. They're not talking about the fact that if you are, somebody who won the DNA lottery, your mom or your dad donated 6 figures to some library at a university to build up the endowment. Well, guess what? You get to get in. That's okay. But it's not okay to have what they're calling race conscious college admission. So I want to break this down and talk about it a little bit. First of all, in this case, the court considered whether the admission system used by not only Harvard, by the way, but also the University of North Carolina. So these are 2 of the oldest institutions in the United States in terms of higher ed. And they are determining, right, whether this was even lawful for them to use those procedures. Affirmative action is not monolith, right? Like, this is not one thing. There were many different ways. Every institution has its own procedures. I'm going to share a little bit in this video about Harvard's procedure, which was very specifically outlined in the court documents, which I've spent the morning reading. So I think you'll find that very interesting. But, Harvard has a $41 billion endowment right now, and former alumni churning money into these organizations, these institutions, is a big way that they continue to grow in their power. And so it's tricky because, a full pay student, because let's be real, we are in late stage capitalism right now. Full pay students have a very special appeal, and especially if full pay means that you're getting that free whatever building it is you want to build and put somebody's name on it, right? These are actual sort of quid pro quo backdoor arrangements that are happening in America's higher education system. And it's absolutely corrupt when you think about the fact that we talk so much about a meritocracy. I mean, what a myth. The idea that there's anything remotely fair going on here is just a joke. There are definitely so many Black and brown students who are going to be hurt by this. This is going to marginalize a huge chunk of folks who should be able to access the higher education pathway of their choice because they're working hard, they're making the right moves. Equality and equity don't mean the same thing. Look it up in the dictionary. Equitable means that we help those who are starting from so far behind the same starting line. That's equitable is not the same thing as we're all the same. We're all, this idea of colorblind, please. So the court itself, right, in the decision, there was a phrase that stuck out to me. It said that there is an inherent folly in trying to derive equality from inequality. And they were trying to make a point about equality. Brown versus Board of Ed, they were talking about Bakke, they were talking about some of these other sort of precedents in these court cases. And listen, I'm no lawyer, but because I have dedicated my entire doctorate to understanding the higher education piece, I believe that I've got firm ground to give an opinion here, which is to say there's a lot of naivete in the way that this is being framed. We're longing for a fairer and more just nation, but do we believe in Santa Claus now? Like, oh yeah, tell me the one about how we're all equal. Yeah, right. We're not all equal. Your DNA lottery determines how equal you are. You know, how much money do your parents have? Did they have money to put you into a test prep program? Did they get you private tutors? Were you able to hire independent consultants to help you get through college? And no shame on that, because guess what? That's how I make my living. And that's how a lot of the best people I know, the most knowledgeable people I know about this topic, are independent educational consultants. We are just taking a huge step backward. This colorblind society that they're talking about, that is just gaslighting. There's nothing colorblind. This is America. This entire country was built on racism and exploitation. I mean, you can get mad at CRT all you want, but give me a break. You know, let's be honest about some precedent there. Let's be honest about the generational trauma that so many people have had to come up and out of. So I just really feel deeply disappointed. And I am now going to tell you about Harvard's policy. So this is what happens. You've always wondered, right? Like, what are they doing in that admissions office? Well, it came out in the opinion today. So I am going to read from the actual document of the Supreme Court analysis. So at Harvard, each application for admission is initially screened by a first reader who assigns a numerical score in each of 6 categories: academic, extracurricular, athletic, school support, personal, and overall. So notice school support, right? Interesting. For the overall category, a composite of the 5 other ratings, a first reader can and does consider the applicant's race. So in that category, they were considering the applicant's race. It wasn't just its own separate thing. Harvard's admissions subcommittees then review all of the applications from a particular geographic area, and the regional subcommittees make recommendations to the full admissions committee, and that at that point, they are also taking into account applicants' race. Now, 40 members of that full admissions committee, that's a lot of people to come to consensus, begin their deliberations, and then they begin the relative breakdown of applicants by race. They have a thing at Harvard, and again, it's different from school to school, so affirmative action is not an identical policy per se happening in all these different institutions. But here's what they do at Harvard. They call it the LOP, L-O-P. The last stage of Harvard's admissions process, called the LOP, winnows the list of tentatively admitted students to arrive at the final class. So doesn't it just really interest you to think about, without affirmative action, who's going to get the LOP now? So it says on this document, applicants that Harvard considers cutting at this stage are placed on the LOP list, which contains only 4 pieces of information. Listen to the 4, you're going to get mad with me. You ready? Get mad? Here you go. Legacy status, recruited athlete status, financial aid eligibility, and race. Think about that. Who gets their thumb on the scale for preferential treatment as we take affirmative action off the table? Wow. Well, I'm so happy for all you wealthy legacy kids. Good for you. And all you recruited athletes whose parents have spent tens or hundreds of thousands of dollars on all that athletic training so that you could row crew at whatever school. Must be nice to be full pay financial aid eligibility. Gosh, it's so nice when you don't have to ask the school to help cover the gap of need between what you can afford to pay because you're Pell Grant eligible, because your parents make maybe, $25,000 a year or some amount. Poverty should not be a barrier to education when the human capital that this country depends upon requires that we have pathways for students who are gifted, exceptional, capable to get there, not on the basis of money, legacy, and athletic status. So at the end of the day, today, June 29th, 2023, is the day that the Supreme Court of the United States said that there was a violation of Title VI of the Civil Rights Act of 1964 and of the Equal Protection Clause of the 14th Amendment. They have cited against affirmative action. And so I guess now we'll see what's left of that American dream we keep hearing so much about. All right. I'm Pamela Donnelly, and I'm really worried. Bye for now.